So, welcome everyone. This is our legal health check masterclass, and we've invited the lovely Fiona McCord from Base Legal, who is sitting right next to me here today. It's always nicer to do these when we're sitting in person. And Fiona is going to run through some of the top 10 questions that we've gone out to some of our kin in various different industries and asked them, if you had a lawyer sitting in front of you for an hour, what would you like to know about? So we've pulled together these 10 questions, and I think when I sent them through, they were quite common things that people need to know about. So we'll get started. The way we usually run these is that we'll introduce Fiona, run through the 10 questions. Any questions you might have while we're chatting, just jot them down, because we will stop at the end and allow around 10 to 15 minutes for any questions that you might have, and Fiona can chat to you then. So without further ado, let's introduce Fiona. And I think everyone that's probably on this call is running a small business, and it can get quite complex and tricky, and especially if you start off as a sole trader and then grow your business. So what we're looking to do today is for Fiona to give you a bit of a legal health check. So with her experience and expertise working with small businesses, she's probably going to cover some of the key things in each of the areas we're discussing that will help you work out, okay, I think I've got that covered, or maybe I need to get some more help or advice in that area because I think I might be at risk, or perhaps I don't understand enough about it. So the whole idea of today is to help you decide whether you need some extra help or whether you think you've got it all covered. And some of you may be here just for that, pat on the back that, I have got it all done, and I'm feeling comfortable that I've got all the areas covered. So I might quickly hand over to Fiona, where she can give you some brief background about her experience.
Sure, thank you. So I have been in the legal industry for 20 years now, and I've been a lawyer for 11 of those years. I've worked in a variety of places, which led me down a path of often working with small businesses. My last role was actually in the small business compliance and deterrence team at the Australian Securities Investments Commission. And one of my roles there was to decide when to prosecute small businesses when breaches of the law had happened. And I just constantly found that I was recommending no, because the businesses were in trouble because they had bad advice or no advice. And that led me to almost 2 years ago, starting up my own practice, which is just me at the moment, helping small businesses. I saw a gap where there was limitations for businesses to access affordable and practical legal advice, and that's the niche I've hopefully been filling. I think I have done okay at the moment. In nearly 2 years, I've helped 400 businesses.
Wow. You've been busy?
Yes, with a variety of things. And from that, as you said earlier, it's working a lot in these areas where these 10 questions.
Yeah. And I think probably one of the biggest fears, and, it's 3 years ago that I went from corporate to having my own business, is you have no idea what a lawyer is going to charge you. You don't know how the fees are structured, and it could be this sort of bottomless pit once you open this can of worms and start asking questions. And also you don't know what you don't know, so you don't know where to start. And so it's all sort of put in the too hard basket. So hopefully today it won't be seen as too hard, and it'll make legal advice seem a little bit more accessible. All right, so we're going to kick off with our small biggest business legal top 10. So I'm going to fire the questions away at Fiona, and she's going to give us some insightful answers that can shed some light. So probably where we'll start, and I've structured the questions in a sort of beginning your business and as you get further down your business so that it moves in a chronological order, is, are you structured right? And I know that a lot of people, just due to cost reasons, start off as sole traders, and then their business grows and they're sort of stuck in this sole trader situation, or they've picked a structure that may not work for them down the track. So probably just to throw over to you to talk a little bit about structure.
I guess the first thing I would start by saying is that it's very personal, and you shouldn't worry about what other people in your industry are doing. I mean, everyone's probably aware that there's the option to be a sole trader, a company. If you work with someone, there's a partnership or a joint venture arrangement, and then there's also the use of trusts in any type of structure. Some things that you need to think about when deciding what structure is best for you is not just about your business goals, but your personal assets and your personal financial goals. You should always talk about structuring with your accountant as well for those reasons. Other things that you need to be aware of when you are looking at the right structure is thinking about whether the business will own any assets and whether the business might incur debts. That will help guide which option is better for you, whether you're going to take on employees. And then there's obviously tax benefits to certain structures.
So would you recommend having a discussion with your lawyer first, with your accountant first?
Yes, I would suggest accountant first, because if people come to me and they haven't seen their accountant, we don't have the objectives for me to say, okay, this one legally is best.
Yes, okay. So if you are sort of aware that your structure needs to change, have a chat with your accountant, talk to them about the best scenario regarding, where your business is heading, the type of business and your personal assets, and then bring all that to a lawyer to then have a chat with them.
Yep.
Okay, perfect. So if we look at business liability and personal liability, a lot of people don't even know. You'll say, well, I don't know what you're talking about.
Yeah.
And then it's like, well, what's the difference? And sometimes it can be, well, I need someone to sit me down and explain from the beginning what this is all about, because I'm a bit scared that I'm ignoring something that's very important.
Yeah. No problem. So I guess a liability as a starting point is an obligation and a responsibility that you're exposed to. It sits in the background, and it's probably that nervous feeling that you have, your stomach churns. So you don't always know what that is going to be. So it's a bit of an unknown. But if you look at it as an obligation and a responsibility, normally to pay money, that's, I guess, the first place to start. Personal liability then is an exposure to you personally, where your assets or you as an individual could be required to pay or required to perform an obligation or could be sued.
Mm-hmm.
A business liability, it starts coming to structure, because if you're a sole trader, the liability is personal. When you have a company or a trust, liability will be kept in that structure.
Mm-hmm.
And it gives you some separation between your personal assets and you as a person versus the business, where it kind of is confined.
So an example, we were running a workshop, and the venue where we were paying a high fee to use it wanted to know that we had liability insurance, so that if someone tripped over our computer cord or something like that, they wouldn't be suing the venue. They would then come to us if there was any damages. So would that be business liability that needed to be covered?
So there's product liability insurance if you're a manufacturer, for example, and I think it's just called some type of public liability insurance is what you can do to protect the safety of others.
Yes, which is what we had to then go and do and get a small insurance policy, because we weren't even aware that then, if that happened in our workshops, that we'd have to make sure that we'd covered ourselves there.
Yeah.
Okay, so sometimes that's that kind of liability needs to be discussed with an insurance broker. Yeah, just to make sure that you're covered so that you're not at risk in that area.
Yeah. You might also want to, when you're thinking about these things, I would say that the best thing is for you to brainstorm about where your exposures might be, what might someone sue you for, what can go wrong.
Mm-hmm.
And then you have a bit of a plan when you speak to an insurance broker, because often they'll need to tailor policies.
Mm-hmm.
It might not cover your needs unless you actually tell them what your needs are.
Mm-hmm.
And you might also want it reviewed by a lawyer because insurance doesn't necessarily cover everything. There's often exclusions.
Yep. Okay. So number 3, and this is a big one, especially with a lot of our kin being online retailers or bricks and mortar retailers, around refund policies, and especially for us with Of Kin, even running workshops and online courses, for a while there, we didn't have any formal terms and conditions as to if someone cancelled last minute or just didn't turn up on the workshop day, how are we going to manage that?
Yep, sure. So terms and conditions are great, and I do recommend that they are used to set obligations and expectations, because often when issues arise, if there's any confusion, it's not going to assist in resolving it. With refund policies, refunds are actually set in the Australian consumer law. And there's a guide on this, which I'll arrange for the link to be made available. But it's an ACCC guide for businesses on the Australian consumer law. And how it works is that guarantees, by virtue of having a business, the law says there are certain guarantees that you must meet. And it depends on whether you're a retailer or a service provider. Retailers have a lot more, and that's sort of the commonly known things like the product has to match the description, be fit for its purpose. With service providers, it's more around that you have due care and skill and that you provide your services in a reasonable time. But it's when these guarantees aren't met is when a consumer has refund rights. They only have a refund, a consumer only has a refund right when there has been a major flaw. And this is often misunderstood by consumers that just want refunds because they're not happy. As a provider or a business, it's only if there's been a major issue with the service. If it's something minor, you have the right to decide whether you give a refund or not, or whether you fix the problem.
Okay. And if they're not happy with the response, is there anywhere that a consumer can go and it can sort of blow up into a bigger...
They can go to their state trading agency, so Office of Fair Trading or Consumer Affairs, they're normally called. They act as a bit of a consumer advocate and will approach the business and say, we recommend that it's in their favour and that you should refund. You can disagree with them as a business. I've got clients doing in this process at the moment. However, it just starts becoming a cost exercise. And also always weighing up, negative publicity and feedback. So often I find businesses refunding people as a commercial decision rather than worrying about the legal aspect.
Okay. And with terms and conditions, most people these days have a website. Should every website have terms and conditions just generically, or only if you're offering transactions?
I think honestly only if you're offering transactions. It depends on what you do, because I'm all for tailoring things, and I don't believe generic is even going to necessarily give you any protection for what you need if it hasn't been tailored. So I normally recommend terms and conditions for any website with an interactive function. If it's just a website for advertising,
you like a brochure site,
like mine, there's not really any functionality. It's not necessary. From a legal perspective. There's other reasons why you might want to. You might want to beef up intellectual property or copyrights, but terms and conditions generally form an agreement between you and the other person. So if there's not really anything for you to need to agree about, they're not going to be necessary.
So if you were perhaps a photographer with a lot of your images on your site, you might want to have terms and conditions of use of those images.
Exactly.
Right, that makes complete sense.
Or some people just prefer to have it on their website that then they can send links and say, well, here's my terms, even though they're not engaging you through the website. It's a place for them to live, and you can attach them in an email link.
Or through social media or anything like that. That's a good idea. All right, so probably one of the biggest discussions, and this was on our private Facebook group too, it came up a bit last week, is all about copyright. And the copyright for a lot of our kin has the two sides of when you're posting on social media, and you've regrammed somebody's image with full credit and using that image within your own feed or social media, but also people's use of your images. And if you are, and we've got photographers and videographers and stylists and people that create these beautiful images. So it's one of those areas where the opinions can be, well, if you fully credit it and reference them or link to their site, then that should be okay. And then others are like, but no, it's their creation. You didn't ask. It's a can of worms.
Yeah.
Is there any guidelines that you can give to keep people safe?
Definitely. So I guess the first point is it's different in every country.
Okay.
So in Australia, the way that copyright works is that the person that creates the image, the sound, whatever the thing is, automatically has all ownership rights in it. You don't register a copyright anywhere in Australia, but you use the little C symbol with your name and the year that you created it to tell everyone that you are the person claiming copyright and ownership of that image. If you don't use the copyright symbol, you can still claim it. That's fine. It still exists in the owner. But if you are releasing them, that's a way to tell the world that they actually need to contact you if they want to use it. Which I guess brings us to where you sort of the can of worms was, is because there actually isn't one. So depending on any rights you give away to a social media company, so Facebook or Instagram, I know Facebook's terms, I don't know Instagram's terms, they will say where the rights sit and whether you've given any rights up. If you haven't given any rights up, under the copyright laws, no one is allowed to use, reproduce, edit your image or the item without your consent in a substantial way.
Yes.
And substantial gets a bit cloudy because it's not just substantial as in 75% or a percentage of the content. It's also considered in importance. So, for example, that's when you start getting great speeches like Martin Luther King. We don't know the entire speech, but we know, the I Have a Dream part, which is substantial because it's so well known.
Yes.
So even though it's not the longest part of the document, it's substantial because of its how well known it is.
So if someone was to regram another person's image on Instagram and they haven't indicated on their account that, do not use my images or not to be reproduced, but it's fully credited, is there a risk there?
Yes, because you need permission.
Okay.
You need permission, and that's the point of putting, because that's a reproduce.
Yes.
And no one has the right to reproduce unless you give it to them. This is obviously without knowing whether Instagram says it's allowed. I don't think they do, though. I think I've heard this issue before with Instagram, and it's just the internet generally. People thinking I found it on the internet.
Therefore, it's free
I've
use.
even had people in my own marketing material give me images, and I've said, "Where did you get it from?" On the internet, and I have to say that's not it's not a place.
They chose the wrong person to do that.
So it's a really big misconception.
So I guess the advice would be proceed to regram at your peril. It's a personal decision you need to make if you want to take those risks or not. And also that if somebody has reused one of your images without permission, then they are breaking the law, copyright law. All right, we could discuss that to way more depth than that. But there's some within Australia, I think it's the Australian Copyright, there's an association that has a very good document that pretty much in legal terms summarises exactly what you've been talking about, if anyone would like to read a thorough legal document. So question number 5, competitions are just flooding the market with social media because of the ease in which you can now run a competition. You've got an audience there that you don't need to pay a huge amount of money or marketing to get access to. So there are people left, right and centre running competitions. However, just because they're easier to run via social media or through email mail outs, it doesn't mean you're exempt from permits, that there are particular guidelines you need to follow on sites, and just the, what sort of prizes you're offering. And then there's, the site rules that are specific to each site, which I'm not expecting you to reel off now, but I know one of my bugbears is that if you do read the Facebook terms and conditions, it quite clearly states you cannot ask somebody to share your competition. It is against their rules and guidelines, yet there are people left, right and centre running competitions and asking them to do that. But Facebook does shut your competitions down, and I know a couple of people just locally living where we are that have had theirs shut down where they've been asking to share. So it's not just the social site rules. There are other larger laws that still need to be followed, even though it seems like you're just running a small little competition.
It's actually that complicated that I've never done one. I guess and one of the reasons why is because each state in Australia has its own laws. So if you're using a medium like social media and don't restrict entrance to your state, you're potentially breaking the law in another state. And I haven't yet come up with a way to do a competition that complies with every law in every jurisdiction in Australia.
Yeah. And that's saying that your social media following is just in Australia.
Exactly.
I mean, the minute you get overseas, that's again another one of those can of worms.
Yes, and Facebook is pretty good with actually explaining what's banned in certain countries as well, which helps. And you could just pick countries and not allow entrance from there. But I guess one of the main questions is, do they need to be registered? In Victoria, no, they used to be until last year. Other states, yes, if your prize is over a certain value.
So that's not about whether your business is located in Victoria. It's that it's for people only. So you must need to restrict it just to Victorian entrance.
Yep.
Okay.
So you don't need a permit in Victoria, but you might elsewhere, or you register it and you need permission. Generally, that applies if your competition has no skill involved. So the words they use are if it's a trade promotion lottery. So if there's any requirement involving chance that you might win, you fall within the regulated competition. I basically say a game of skill is if I do A, I win B. And I say it's like putting the balls in the clown at the fair. If I get one ball in, I get the plastic bracelet. If I get 3 balls in, I get the toy dog.
So would the describe in 30 words something, is that a game of skill?
People use that as a game of skill.
Okay.
But it isn't on my interpretation, because a game of skill is when the entrant, not the competition runner knows when someone's going to win.
Yes.
It's when the entrant knows when they're going to
win. Okay.
So if there's any chance on their behalf that they might not win, then it's not a game of skill.
Okay.
And again, there are, as you mentioned, social media rules about running competitions, which generally under both the state law and social media is that you need terms and conditions for your competition.
Yes.
And they're pretty basic. It's just explaining any restrictions on entry, what the prize is, what you use the person's information for. So if you're getting email addresses that you're going to use for marketing, you need to say that.
And also the time. I mean, the unfortunate thing is if you don't say the date and the exact time of entry closing, there's always that one person on that one competition that says, well, I entered in time, but and then you've got this argument about those kind of things. So it's just best to cover yourself, really. So what I'm gauging is check the permits required for your state to have terms and conditions which just run through all the details and make it very clear for entrants so that there's no disagreements around anything, that your prize is of a certain value or it doesn't go over a certain value as well is something to consider. Once it's over a certain value, it needs to get a permit. and that it's different every state, and that if you're running it on social media, you need to be aware of the guidelines across each of the social media platforms as well. So if that hasn't put you off running a competition, I don't know what will. So next time you see a competition being run on social media, that's when you'll start to look at it and go, I wonder whether they've ticked all those boxes. And look, probably one day someone will be used as an example, so that there can a precedence be set. I don't think that's happened yet, as in has publicly been shown this, a small business running a competition that doesn't fit all of those things hasn't really been used as an example yet.
And you'll see that a lot of people are actually doing it with their terms just in a link on the side of the competition.
And that's another great example, where, on a Facebook competition, you can put a link into your website for competition terms, or do it in a blog post on your website just to have that covered. So moving on, a lot of our kin are freelancers or using freelancers or contractors or contracting out work, or, working in a team with other people to do things. So the structures and the liabilities of who's responsible when something goes wrong can be a little bit grey. So maybe if you could perhaps talk a little bit through those scenarios.
Yeah, I mean, I'd always recommend that it's documented in writing, and in that course is when the liability is discussed.
So prior to the arrangement being set up?
Yep. Or generally one person, one side, if there's a bigger business, might be the one that produces the terms.
Yes.
But generally, coming back to how the consumer law works, if there's a consumer at any part of the transaction, the liability to the consumer is the person that's facing them. So if you're the contractor, it's you, and then you deal backwards with whoever is in the agreement behind you. And freelancing might be reversed, that whoever's hired you deals with a consumer issue, but then they seek from you a refund, or they might terminate you because of what's happened.
Yes, okay. And as far as having an agreement, I mean, is that something could it be written in lay terms?
Yes.
So it's just an understanding and something that both have agreed to and signed, so that if something does happen, it's not, well, I didn't know that I was responsible for that kind of discussions happening. Okay. And are there any standard agreements that you can use for these, or are these again specific to the relationship and the types of businesses?
It depends on the businesses and what it is exactly.
Okay. Beautiful. All right. Intellectual property. So this question actually was a discussion I was having with the videographer that does the videos for our e-courses, and I sort of said, what would you want to know about if you had a lawyer sitting in front of you? And his response was, we film all of this footage and videos. Who actually owns that footage? Because the customers paid me to film it for them or to film them. Are they the end owner of that, or is it me, or is that something that I should be stating up front to make that decision? And that comes for photographers as well. We have a lot of photographers as our kin. Any designs, logos, graphic design, all of that kind of thing, just to sort of help us understand what the scenario is there.
Yeah. And look, it's not really a straightforward answer. So I would say, as a starting point, whoever owns it comes to the document, all the terms, or whatever it says. How it sort of works is, as I indicated before, with things that can be copied, that fall under the Copyright Act, which would be photos, images, logos, designs. The ownership is automatically with the person that created it, and the rights then need to be given away to the customer.
Okay.
However, there is an exemption where if you are hired to do it for that person, it sits with them.
With who, them
with
being
the person that paid for it.
Okay.
So it sort of depends on. I tell people to just deal with it outright in terms.
Yes.
Because I think if you're producing it for someone else, I would recommend that you have ownership until you've received full payment.
Yes.
And then you hand it over at that point.
Okay.
So even when they're paying for it, it's still not clear at what stage they own it and what stage it flicks from creation into a final product that someone owns.
Okay. And then as far as usage of that, so if you wanted to use examples of logos or videos or anything, it comes back to that whole copyright thing of asking permission of that person to use it on your website or in your brochures?
I would recommend, what I do when I do written terms is normally that the creator hands it over but keeps the right to use it for the limited purpose of advertising or portfolio.
Yeah, and just cover that off in the terms.
Exactly.
Yeah. Okay. So what I'm getting out of the answer to this is that to save any ambiguity or misunderstandings that you can never really predict when and where that's going to happen, to have some form of agreement that's signed by both parties that states clearly how you're going to manage ownership and at what point that occurs.
Yep.
Okay. And I think this ties nicely into our next question, which is all about contracts. So we had another one of our kin ask the question because a lot of us are creative entrepreneurs. We're either running from corporate and have left corporate and are trying to relax our way of doing business a little bit, or just creative in general, and business and terms and contracts and the words contracts and legal freak people out.
Yep.
So they've tended to shy away from having any formal agreements when they do business with or pick up a client or are working with people. So the question was, is there some kind of softer alternative to a contract or an agreement or something that can be used with their clients but not be scary and sort of very legally focused?
I mean, definitely that just comes down to language.
Yep.
To have, I guess, what I can share with you, which is, I will try to not make sound too legal, but as you know, we inherited our laws from England, and there's 3 things that are required for a valid contract. And that is that there's an agreement reached between 2 people, that they've both understood and reached an agreement, that money is paid, and I've combined the first 2, so that there's an agreement and a mutual understanding and money paid. And often we have agreements where money isn't paid, and they actually have to be in a form called a deed of agreement. And the reason that I'm explaining this is because I've actually seen a lot of businesses in trouble because they sign what's called a heads of agreement.
Okay.
Basically, a heads of agreement isn't a contract, so just be aware of that. And you can Google what the difference is, but it's basically a heads of agreement is just setting dot points out on what we will put in a contract later.
Okay.
And then there needs to be a second one. So sorry, that's a bit technical, but I see that businesses thinking they've got a contract and it's a heads of agreement and it's not enforceable.
Okay.
So unfortunately, you can't avoid having to have a document. It doesn't have to be a document, but those 3 things will always be needed to prove that you had a contract.
Okay, so it doesn't need to be called a contract or an agreement or anything like that to hold any weight legally?
No.
Okay, so I mean, and when I was discussing this with the particular kin that brought it up, I had said that Kylie and I use an engagement agreement, and really what it states is this is the service we're going to provide you, this is what we will not provide you, just in case we discuss things to make it very clear that that's not part of it. This is the amount we're going to charge, these are our terms of payment, and that we won't deliver this amount of service until we've received at least 50% of payment, and then the remainder is however many days after. And then any other little notes or things we feel we need to clarify that perhaps might have been ambiguous, we'll include in that, and then both parties sign it.
Yeah.
So that would hold up legally?
Definitely. It can be a letter, a proposal. I do a lot of people say client agreement, like a letter of engagement, terms of service. It can just be your terms.
Yeah. Is a reply email saying, yes, I agree, the equivalent of signing?
Yes.
Okay.
Nowadays.
Okay.
Yes. All right. And they'll look at everything. They'll look at if you did one act under that agreement, you've acknowledged it.
Yeah.
and agreed to participate.
Yes.
So it's very holistic if
Okay.
you want to rely on emails and phone calls as well.
Yeah. Okay. Well, hopefully that's cleared up a lot of things for people. And all of you that are putting off setting something like this up, once you've done it once, you can pretty much use it as a template and just, change the details in it. And it just gives you that peace of mind that you've got something you can call back on. And you may not have any disagreements or had any yet, but on the one day that you do, it's really nice to actually be able to pull it out and go, actually, it says quite clearly here and you've signed it, which we hope never happens. All right, so we're kind of moving through. We've done the work and we're now on to the whole payment side of things. And in those horrible scenarios, and I've only had one and it probably took about 3 or 4 months to get payment and I got every excuse under the sun. And I never went to debt collection levels, but depending on the amount that you're chasing, if people aren't paying or somebody hasn't paid, what can you actually do? And where do you go and what actions can you take?
Sure. It's an unfortunate part of business and doesn't happen to me much.
Yeah.
Luckily, because of what I do. But I mainly discuss about what you can do to prevent it actually happening, because chasing debts is difficult and time consuming and can be costly. And for me, I look at it as what can you do to implement a process from the beginning to actually reduce the instances of people not paying.
Mm-hmm.
And that's with having things like terms in place or agreements, getting deposits,
Yes.
using progress payments, withholding the product until full payment is received. And you do that in your terms or your agreement. Chasing debt, I guess the first thing I would say is that you need to be prompt and you need to be on top of it at the time it's due. A tip which I find quite useful to pass along is that someone doesn't owe you being owed money, it doesn't become a legal debt that you could take action against until it's past the date due. So you need to be really careful in discussing extending that date, because if you agree to extend the date, you create a new due date and you wouldn't be able to take any action for the failure to pay from the first date. So when you have conversations and if you want to give someone more time, the way to frame it is that I won't take action if you pay on new date.
Yes.
Don't say I agree to let you pay on new date, because you've just created a new date for payment. It's not a debt anymore. It starts being a debt on the next day after.
Okay. That's a really valid point.
Yeah.
Especially if they say, oh, can you give me another month? Then you can't do anything for another month.
No.
And if it's a substantial amount of money, it could impact your cash flow for a period of time.
Yeah.
All right. And is there, threatening legal action, is it even worth doing that? Are the costs of legal action worth it?
Small business, you can go to VCAT.
Okay. And there's no costs involved there?
It's very limited.
Okay.
There's a small application fee and they will make a mediation as the first step. But it can be 6 to 8 weeks wait.
Okay.
And then if they don't pay a VCAT decision, you actually have to go to the magistrate's court to get it enforced, because it's only a tribunal. It's not court action. You can't do anything with their credit ratings. Okay. So that's why I sort of suggest you focus on the front end processes as to how to reduce the instance of people failing to pay.
Yeah, I think that's very smart. And I think withholding, once someone's got everything and they sort of go off and they're running their own business, they kind of ignore the fact that they need to pay. So if they haven't got what they wanted from you, and they've got some money tied up in a deposit as well, and they haven't even got the product, it kind of creates a greater motivation for them to pay.
Yeah, exactly.
Cool. All right, so on to our final question, and this was a bit of a throwing it in there just to pick up on some different scenarios that some of our kin out there might be in or considering or have been through, is if you're actually buying into a business or selling a share of your business to somebody else, you might, realise that you're stronger with a different talent to come in and join you, or you're a yoga studio and one of your partners is leaving and you want to bring another one in. So what sort of things to consider?
Will you go back to question 1 and look at the structure that's best for you in this new in the new business. You're not tied to whatever structure exists. You need to make a decision about what's best for you. Obviously, you need to do some, it's called due diligence, but checks on what you're buying into. And there's a whole lot of things that you can do, paid searches, but publicly available information if you pay, because you need to make sure that you're not taking on hidden debts that you don't know about. And you need to understand where assets are owned. You might think the yoga studio is owned by the business and you're going to get an interest in the property, but it's not. It was owned in a personal trust, and that isn't an asset that you'll have an interest in. So this is a process that is normally done by exchanging financial information and seeing the books and records before you buy into something. Even though I know that can sound serious, or you think, I don't have any books, I've just got zero. But it's looking at assets, debts, bank accounts, looking at transactions.
And assets like databases, Instagram followers, all of those things. I mean, there's a lot of goodwill there that person's built up. So they could well say, well, this is worth this amount of money to add on to the amount that you might be buying into.
Yep. And it's whether any agreement should also say whether there is any interest. So, for example, if you are buying into a business with 11,000 Instagram followers, if you're taking over from someone that's exiting the business, they might get paid out some money for that, but the new person the owner that's left might say, I'm actually keeping this, and the sale of agreement will say you only have interest in the followers built up from this certain date.
Yes, okay. So it's important to clarify which things are going with the business and which ones aren't, and which might be attached to the person, not the business.
Especially with intellectual property.
Yeah, okay. Well, what we might do now is, because every business is different and I'm sure you've got very different questions, is open up to questions that may have popped up on some of these topics that we've covered now. We've got one question there waiting for us already. So anyone else that's got questions, please fire away, type them in. Fiona's willing and able and ready here to guide you and give you some direction on some things that you may be dealing with around these topics in your own businesses. So our first question is, what is the best phrase to use on a quote? Is it deposit or booking fee for the customer to pay something to secure a booking for a function?
It really doesn't matter from a legal perspective. What you would need to be careful about in this situation is if it's going to be non-refundable. So under the consumer law, as I discussed before, people are entitled to refunds in certain situations. So they've actually made it an offence to use the word no refund. So if you see that anymore in shops, the fine's up to 1.1 million. It's huge.
That's enormous.
Because they want consumers to be aware that they do have refund rights.
Okay.
So the wording I use is to explain that we need a deposit to secure your booking, have a cancellation policy, or if it's not refundable, just explain it's not refundable because we haven't late notice, we can't fill your spot.
Yes.
So even though you are allowed to have a non-refundable deposit, you need to be really careful about the wording. But those words, deposit or booking fee, there's no legal difference really.
Okay. So a question I've got is running e-courses. People sign up and then they might sort of circumstances change and they don't have time to actually do the e-course. If it's stated in the terms and conditions that, maybe we can see that they've gone in and actually looked around and done, gone into different lessons, but a week later they decide they don't want to do it anymore.
Yeah.
Even though it's stated in our terms and conditions, if the course has commenced and time has passed, we will not refund you because they've had access to all the material and, whether they're doing it or they're seeing what we do as a competitor or whatever, we won't refund. Legally, can they contest that if it's in the terms and conditions?
No, so the way it works, it doesn't matter what's in the terms and conditions because the consumer law is always going to override any terms and conditions.
Okay.
But the way that the consumer law works with refunds, so they're only entitled to a refund when there's been an issue, a major flaw or a minor flaw. You do also need to look at whether you've delivered a service.
Yes.
So you're only entitled to be paid when you've delivered a service. And that's when you use your terms to explain when that is delivered. And a business also has the right to rely on a commitment that a person's made to forecast income. And in acknowledgement of that right is when you are allowed to keep fees and that type of things. It can never be a penalty. So if you keep fees for a service that hasn't been provided in full, it needs to tie back to something that is quantifiable if you are asked about it. And in your case, I definitely say to people that if they've had access to your intellectual property, well, that's what they've got. And they could have accessed 12 weeks worth of content in 1 week and downloaded it all and still getting the benefits. So it depends on how an e-course is run. Some people only release it weekly, in which case they haven't accessed anything yet.
So we haven't delivered the full service at that point.
And it's that sort of, but you are always allowed to rely on a commitment that you will have income coming in. So, and that's how gyms get around gym membership fee.
Yes, I think we're all familiar with that. Were there any more questions for Fiona while we've got her here live relating to your business or scenarios or potential risks you feel that your business might be in at the moment? Just type them into the questions area. Otherwise, if there aren't any other questions, we might wrap this up and let you get back to work. We'll just give you a little bit longer if anyone's just in the middle of typing at the moment. But thank you all very much for your time today. While we're waiting on any questions, just wanted to let you know if you wanted to contact Fiona and discuss anything further or use her services to help with any aspects of your business, all of her contact details are there. Her best probably is email at info@baselegal.com.au and then find her Base Legal on Facebook and Fiona McCord Base Legal on LinkedIn. And
I do also actually offer after hours appointments because I know a lot of people are building businesses while they work.
Yes. We've got a lot of those. The slashies that are full time hoping to cut back and move across.
So Absolutely. I've got a couple of nights a week that I can offer after hours appointments.
Brilliant. And Fiona also has a legal health check. So I don't know whether you wanted to talk through what's on offer with your 60-minute consultation.
Basically, it's 60 minutes like this, but for you to just pick my brain. I've got things that I can talk to you about, but otherwise we can use the 60 minutes however you need in relation to your business. So it might be that you want me to review a document and I'll spend 60 minutes reviewing that and talking to you about where you might want some changes. Or you can ask about, your restructuring, what should I do? It's basically 60 minutes for you to spend however you like.
So if you think that'd be a great place to start, Fiona's details are there to contact her and you can make the most of that wonderful offer. So thank you all very much. I don't think there's any other questions. You've probably covered everything that was on their mind, or they've gone off and they're busily reading the Australian Consumer and Competition website, which I'm sure is what's happened. So thanks very much for joining us, guys. We'll look forward to seeing you at next month's webinar. And if you're interested in joining us for the time, workshop starts in April. So we're taking enrolments for that e-course at the moment, starting on the 15th of April. And more information at the OVKIN website, ovkin.com. So enjoy the rest of your day. We hope you've recovered from Easter and we'll see you soon. And thank you very much, Fiona, for your time today.
Thank you.
It's been wonderful covering all of those topics. So we'll speak to you soon. Bye.